Good evening. I'm Marilyn Perkins, and I want to welcome you to this forum tonight. I'm the current president of the League of Women Voters. We have partnered this year with the Latino Coalition of the Tri-Cities to bring you a series of forums. This is the last one that we are doing. Neither the League nor the Coalition endorses any political party or candidate. We do have members, however, that are very politically active. The League is almost 4 more years, or 3.5, 100 years old. We were actually formed before women got the right to vote. We were getting ready. Hopefully this forum will be a benefit both to the candidates and to you, the voters, and the viewers that will watch this later. For any of you that might be interested in learning more about League, we have a sign-up sheet in that back table where Bev is standing. Last week, we sponsored 3 statewide races. The candidates for Attorney General, the Office of the Superintendent of Public Instruction, and the Secretary of State. They were recorded by Mike Charbonneau, who's out in the truck, Bob over here, and John Funfar in Pasco. And if you missed them and would like to see them, you can sign on to the Pasco Facebook page, and under videos, you can look for those races. Mike and John are invaluable to this process because you see we're not overwhelmed with people in the audience, which is always a little discouraging. But having it available for people to watch on YouTube or Facebook, it will also, this one particularly will be on both the Richland and Pasco stations. I think they're 191 in Pasco and 192 in Richland, and they'll be on YouTube. I did already mention the governor's race that will be at CBC this coming Wednesday night. We have a full evening tonight, and we'll be hearing from the candidates for the State Court of Appeals, Division 3, Superior Court judges of Benton and Franklin counties, and the 8th Legislative Congressional District, which will start about 7:30, though we're running a little behind. And as I said, in case you didn't hear, as a reward for coming, we have cookies. So help yourself, though I forgot the napkins. That's my fault. Our first 3 segments will all operate under the same ground rules. All the candidates will have 2 minutes for an opening statement, 90 seconds to answer the questions, and 1 minute for closing. None of the candidates have seen the questions. We have 3x5 cards in the back of the room, and somebody, Ruth, can hold up your hand if you want a card, and Ruth will give you one. We ask that the questions not be of a personal nature, but stick to the issues. And the candidates haven't seen any of our questions, or hopefully your questions, maybe they have. We will alternate on who goes first in answering the questions. Okay, the appellate court in Washington was established in 1969 to help reduce the heavy workload on the Supreme Court. It started with 12 judges and now has 22. There are 3 divisions based in Seattle, Tacoma, and Spokane. The judges serve for 6 years and must retire at the end of the year that they turn 75. We will now hear from the candidates for the Court of Appeals, Division 3, District 2. And as you saw, we tossed to see who would go first, and Mr. Bernie will open with his opening statement.
2 minutes. 2 minutes, you said?
2 minutes.
All right, thank you. Good evening, ladies and gentlemen. My name is Patrick McBurney. I'm a candidate for Court of Appeals. So our state constitution in Article 1, Section 1 states that all political power is inherent in the people. In order to have a functioning democracy, we must have regularly contested elections, and that is one of the main reasons why I'm running for this position. I'm running in this election to provide a credible alternative to Judge Fearing, and if I'm elected, I believe that members of the judiciary will be on notice that political power truly is inherent in the people. I have said I'm a longtime resident of the Tri-Cities. I've been in practice here as an attorney for 23 years. I have a very diverse legal practice. My campaign is endorsed by former Attorney General and gubernatorial candidate Rob McKenna, congressional candidate Clint Didier, and former Congressman Doc Hastings, among other endorsements. So I think that just to make this quick, why me over my opponent? One, I'm running to provide judicial accountability by providing a contested election. Two, I believe that some of our courts, especially the state Supreme Court, believes it's unlimited in its authority, and electing me will send a signal to the judiciary that the people are ultimately in charge. And four, my practice is somewhat different than many of the members of the current court, and I think that I bring a unique experience having represented people who are of limited means and are usually indigent. So that is my opening statement, and I thank you for your consideration.
Thank you. We will now go to Mr. McBurney. I might mention they're getting a 15-second warning and then a warning to stop. They don't have to just stop dead, but just finish your sentence, and then we'll move on. Okay, Mr. Fearing?
I hope I don't have to stop, Dad.
Me too. So it might give us a little more PR. But it's not worth it, honest.
I don't know what to say after that. My name is George Fearing. It's been my honor the last 3 years to serve Benton and Franklin counties and 7 other counties on the Eastern Washington Court of Appeals Division 3. I was appointed and then elected in a contested election in 2013 to the position. The Court of Appeals is unlike the Superior Court or trial courts. We're rarely in the courtroom. Instead, I read and write, and when I'm done with that, I read, and write. And when I'm done with that, I read and write some more. Before becoming a judge, I was a trial attorney based here in the Tri-Cities. My specialty was representing law enforcement officers. I am honored to have the endorsement and support of prosecuting attorneys and law enforcement officers, including sheriffs and chiefs in the Tri-Cities. So how does one decide who to vote for in a judicial race? Experience is critical. I handled over 90 appeals before becoming a judge. The Washington State Bar Judicial Qualifications Committee vetted me and rated me exceptionally well qualified, the highest rating. In choosing for whom to vote, endorsements from those in the legal system, particularly judges, are important. The local attorneys have rated me the highest in all categories. I am endorsed by all 15 Superior Court judges in the 9-county district from which I am elected. This unanimous endorsement is unprecedented. This includes all 7 Superior Court judges in Benton and Franklin counties. 3 judges in this area would not endorse me 3 years ago because of my political past. They endorse me now because they know I will stick to the law. I am a bookworm, I love my job, and I look forward to continuing to serve on the court.
Thank you. We'll start with a fairly easy question, but one of the reasons we do this forum is to educate voters, and we're going to begin with you, Mr. Fearing. I gave a brief description of the Court of Appeals, but I think most citizens are not that aware of it and its purpose. Could you elaborate on how the appellate court fits into Washington's judicial system and how well it is working for the citizens of our state?
In a minute and a half.
Well, he can add, so.
Okay. The Court of Appeals is in between the Superior Courts and the Supreme Court. The loser in the Superior Court can appeal, and that appeal goes to my court. The loser in my court can appeal to the Supreme Court, but the Supreme Court gets to pick and choose the cases it hears. My court does not pick and choose the cases it hears. When you hear that someone has a right to an appeal, that right to appeal is to my court, not the Supreme Court. My court is the workhorses of the appellate system. I hear approximately 250 cases a year. I write decisions in 1/3 of that. Supreme Court hears about 90 cases a year, and they write 1/9 of those opinions. We do not have trials. As I've already indicated, we're not in the courtroom that often. We're reviewing the trial court record to determine if there were errors made. And if there was an error made, then we determine whether or not that error was harmful to the appealing party. If there was an error and there was some harm to the appealing party, then we typically remand for a new trial.
Okay, thank you. Now, Mr. McBurney, is there anything that he didn't say that you would like to add that you think is important for people to be aware of
I think
or
as far as
appreciate?
just an educational mode, and I don't think that I think it just because Judge was, kind of limited on the amount of time, but it's very important that you have a basis to review decisions. So when the Superior Court makes a decision, I think that's one of the things that makes our country great, is that we have this system where you ultimately have an appellate court, a state Supreme Court, and if there are issues of federal or constitutional nature, you can always take it to the highest court in the land, the United States Supreme Court, to look at these various things and determine if the law is being followed. It's so that people have confidence that in the system of justice, and the appellate system provides that sense of confidence by knowing that you have a right to have that decision reviewed. And I think that's very important to understand. And I don't think that a lot of people are truly necessarily even aware of that particular right. So,
Thank you. We'll let you start with the next question. This one is from the audience. How do you view judicial appointments, usually from the governor, and how do these appointments have an influence on the decision of the courts? You can speak a little bit to the advantages of appointments versus voting, or voting versus appointments.
well, our system is a system where we elect our judges. Our judges run for office, and in the trial court they're elected every 4 years. In the appellate court they're elected every 6 years. And that is the way it is with the majority of the states. I think there are about 19 states that have some system where there is a hybrid, where there is either a judicial panel that chooses, or the governor appoints, and the judge sits in an election to determine to retain or not. In this particular system in Washington State, we have the right to have these elections. And so the problem with this particular system, from my point of view, and it may not be a problem from Judge Fearing's point of view, is that one political party has controlled the governor's office for 30 years. And as a result of that, that political party has tended to appoint judges to positions. So the way it works is that a judge will retire midterm, the governor will appoint, and most likely because judicial elections aren't very interesting, that person will go on and serve. And I do believe that even though judges are not supposed to be impartial, they do bring their worldviews into their job, and I do believe that tends to make the judiciary skew somewhat left of center. That's my view.
Okay, thank you. And Mr. Fearing?
When a judge, a Superior Court judge, Court of Appeals judge, Supreme Court judge retires in the middle of a term, the governor does appoint. Unlike in a race, a campaign race, there is a substantial vetting process that goes through before an appointment. The candidates are vetted in their backgrounds and their abilities, and the governor makes a decision based upon that vetting. I went through that vetting in 2013, but not only that, I stood for election in November of 2013 with a candidate with the same theme that's being raised by Mr. McBurney here, the conservative candidate. I pledged to follow the Constitution as intended by the drafters of the Constitution. I won that election. I was pleased to win that election in 9 southeastern Washington counties, and beyond that, I have kept my pledge to be faithful to the Constitution as it was intended by the drafters of the Constitution. and I will continue to be faithful. A conservative judge is one who follows the law, not his or her personal opinions. I am that judge.
Thank you. We'll follow up a little bit on that same idea, and we'll begin with you, Mr. Fearing. I know it's hard to start first and then finish last and then be the one to start again. But how will you balance your personal beliefs, be they religious or political, with your duty to interpret the law?
I will follow the law, and I've done that. I've followed the law on some occasions where I did not like the decision, but it's the role of a judge to be faithful to the law, to be faithful to the intent of the legislature when construing a statute, to be faithful to the intent of the drafters of the Constitution. I am a Seventh-day Adventist. I am a member of a conservative faith, conservative Christian faith. That faith means a lot to me. And that may, to some extent, color how I make a ruling, but I very much decide to go with the law rather than necessarily my religious beliefs. We have separation of church and state. And again, it's improper for a judge to have any of their personal beliefs, regardless of whether it's religious or non-religious, involved in the decision-making. I have followed that balance. I will continue to follow that balance.
Thank you. And now, Mr. McBurney.
Well, let me just say this. I believe that everybody has a worldview, how you want to call it, a system of philosophy or beliefs. Is there a God? Is there not a God? Is the, political, religious, social, generally an outlook on the view. Even if you can't even define that, everybody does have this, and people bring this to them in whatever vocation they're engaged in. And just because you pledge to follow the law, okay, doesn't mean that you may not be looking at it from a different point of view. Once the law was described to me as a diamond with very many facets, and how the diamond looks to you often depends upon, at what angle you're standing away from it and how the light reflects off of it. And the point being is that what I am telling voters is that I'm looking at this diamond from a certain perspective. I'm going to follow the law. I'm going to have to follow the law as set out by the legislature and as set out by the Supreme Court, because that's what appellate court judges do. But I may have a very different interpretation than maybe one of my colleagues because from the direction that I'm looking at it. And I believe that is a different perspective, and I believe that I bring a fresh perspective to the Court of Appeals, which is why I'm running.
Okay. Thank you. You can start with the next question. How fair is the judicial system in our state regarding income inequalities that have always existed and will probably continue to exist far into the future? In other words, does a poor person have the same chance at a fair trial as a rich person?
No. And the fact of the matter is that I was just confronted with a client of mine today who we were discussing, his situation, and it's not necessarily whether it's a trial or not, but, when he was in prison, he got assessed like a very large child support obligation while he was in prison. And because of his lack of education and because he didn't know the resources, that judgment has accumulated now into over $100,000. And there's some question as to he never really went back and addressed it. He could have when he was in prison, and maybe if he'd found the right resources, but and certainly if he'd had a good lawyer at the right time, he could have addressed that. But he may very well be saddled with that debt for the rest of his life and never be able to repay it because of that situation. So. Resources do make a difference, and it's not necessarily I don't know the answer to how you solve that problem. You support legal aid programs, you do all sorts of other things, you try to increase access to justice. But, the people who have money are always going to have an advantage in dealing in legal proceedings.
Thank you. And Mr. Fearing?
I agree with Mr. McBurney that the poor do not necessarily have the same quality of attorneys, particularly in a civil case. I'm not sure that's true in a criminal case where the poor are entitled to attorneys, and public defenders do a very good job. Because the poor does not always get the best representation. When I was a practicing lawyer, despite mainly representing the establishment, so to speak, I often volunteered my time over and over again to assist the poor, either on a sliding scale or free. There are a number of decisions in the Supreme Court where I represented individuals for free. One was a lady named Kelly Key who gave birth to a severely disabled child, and the state wanted to remove the child from her because of the severe disability. I represented Kelly Key for free to prevent that parental termination. We took the case to the state Supreme Court.
Thank you. Now you get to answer first. Do you believe justice is better served with mandatory sentencing or when judges have more discretion in sentencing?
When judges have more discretion, there is a pendulum that swings in the judicial system. When I started as a lawyer, the judges had essentially unlimited discretion when sentencing. And shortly thereafter, the Sentencing Reform Act was adopted that put severe restrictions on the discretion of a judge in sentencing. Now the judge has very limited discretion in what to do. I don't know that I want the pendulum to swing back completely the other way, where there was total discretion, but I would wish for there to be more discretion at this point.
Thank you. And Mr. McBurney?
I would agree with Judge Fearing on that. I do think that the pendulum is swinging back in a different direction as we look at the disparate impact on sentencing reform acts on minorities. One of the most enlightening experiences I ever had, I had a friend who passed away, but he was a heroin addict, and we were in the car one time and we were driving back from Seattle because I was helping him fix a warrant, and he had a warrant. And the state trooper pulled up behind me, came up, shined the light in the door, and he said, and I rolled the window down. I said, "Good evening, Mr. McBurney. I saw you over here on the side of the road. Just wanted to know if you were okay." I said, "Sure, Trooper Smith," or whatever. I don't remember his name now, but I did at the time. And he says, "Okay, great. You have a great evening." And he took off. And the expression on my friend's face was priceless. Coming from a gang background, minority background, he says, "That is the first time I've ever been pulled over in a police car, and I have not gone to jail." And that made a big impact on me, and it would certainly be something I would take to my role as a judge.
Thank you. To follow up on that a little bit, how important do you think it is to have diversity on the bench, and what could or should the appellate court do to promote that diversity?
Oh, I think that there is some diversity on the bench right now. There are 2 women and 3 men. The question is there intellectual diversity? And basically, that's one of the arguments that I've been making for my candidacy, that I do bring some intellectual diversity to the bench. I think that we've seen women make tremendous strides in the last 50 years as far as their representation in this profession. We've seen minorities make tremendous strides as far as their representation in this profession, and I expect that to continue. I don't know if there's necessarily anything that we need to do or any sort of program we need to implement to make that happen.
Thank you. This is our last question. I'll warn you ahead because you're going to have to start the closing. But could you comment about diversity?
Eastern Washington is substantially Hispanic, becoming more and more Hispanic Franklin County is either 50% or close to 50% Hispanic. I would like to see an Hispanic on the Court of Appeals, and would encourage the governor or the electorate to eventually have an Hispanic on the Court of Appeals.
Okay, thank you. We'll move on to closing statements because we have to keep this evening moving along. And they only have 1 minute for their final thoughts to help convince you to vote for them. Mr. Fearing.
Thank you. Remember, and thank you to the League for this forum, remember that I stated that all Superior Court judges in this election territory endorse me. They endorse me because of my superior qualifications and consistent performance as a judge. They also endorse me for an additional reason, that being Mr. McBurney's attempt to politicize a judicial race. Mr. McBurney's campaign as a conservative voice is not proper for a judicial race. A judge must be above politics. I am a judge for conservatives. I am a judge for liberals. I am a judge for moderates and those without any political views. I am a judge for you. I am a judge for all people.
Thank you. And Mr. McBurney, you get the final word.
Well, I'll just make these points very quickly. It's true that Judge Fearing ran in 2013 in a technically contested election, but his opponent didn't really campaign, didn't raise any money, didn't put up any signs. It wasn't a truly contested election. This has been a truly contested election, and whether I win or whether Judge Fearing wins, I think that our democracy is better served by having had a contested contest. I'm running to provide judicial accountability in that way, to give voters a choice. I'm also running basically because I think that voters need a way to have an outlet to say that maybe they feel that our courts, especially the Supreme Court, has overreached. So I am providing a clear choice in this election. I've provided a real challenge to Judge Fearing in this election, and however it goes, I believe I would like to ask for your vote in this election. Thank you.
Thank you. And join me in thanking both these candidates. I know they have a very busy schedule this time of year. Welcome back, and we're going to hear from candidates for Superior Court Judge in Benton and Franklin counties. There are 2 positions where there are contested races. They are position 2 with Joe Burrows and Sam Swamberg, who we do have with us tonight, and position 3 with Alex Ekstrom and Marie Berry. Unfortunately, Ms. Berry cannot be here tonight, and when that happens, we can't let her opponent answer questions too, but we try to give each candidate an opportunity to make a statement. The absent candidate obviously has to send someone to do that for them, but Mr. Ekstrom is here, and he will make a statement, and then he will go back to the audience. So we are going to start with a representative for Ms. Berry, and it is Scott Boyce. And just go ahead and speak from the podium.
Hello, my name is Scott Boyce. I'm here on behalf of Alicia Berry, who's running for Superior Court Judge Position 3. First of all, I'd like to say thank you to the League of Women Voters for putting this on and getting such a great turnout. I know how difficult it is to get people out of their homes on a Monday night, so I appreciate all of you being here. I wanted to talk to you about why I'd like you to get to know Alicia Berry better. Lots of times it's easy to feel disconnected to politics, to feel like our president, our governor, they serve us in places like Washington, D.C., or Olympia, and they feel far removed from us. But judges serve us right here in our very own communities. They can have an intimate and important impact on our everyday lives, so it's important that we know our judges. I first met Alicia Berry when I was a student at WSU Tri-Cities, where I was getting my undergraduate degree. She was teaching business law, and when I told her I was eager to go into the law field, she took me under her wing. She helped encourage me. She helped me study for the admissions test. She helped me write letters to the schools asking for admission. And then once she helped me get into school, she didn't quit there. She kept in touch with me. She asked me how finals were going. She asked if I was glad the finals were over. And then during my final year of law school, I was going to come back to this community to search for a job, and she set up interviews for me. She introduced me to people. She even introduced me to my current boss. And so I owe her a great debt of gratitude. I tell you this because I want you to know that Alicia Berry is a caring person and a loving person and a person who cares deeply about this legal community. She's spent years serving this legal community as an attorney. She's served on the Benton Franklin Bar Association. She's served the Legal Aid Association. And she's done amazing and wonderful things, helping out, even serving as a pro tem judge. Alicia Berry has the experience, the know-how, the education, and the desire to serve this legal community. It's for those reasons that when she reached out and asked me to help her with this campaign, I was 100% on board. And it's for that reason when she asked me to come and get up here in front of a bunch of strangers to talk about her, I was more than willing to help out, because I know she is willing to go the extra mile to serve this community as a judge. Now, we've heard a lot about endorsements tonight. And I could list off a lot of the endorsements she's earned, such as the Benton Franklin Republican parties, other elected officials, but none of those endorsements matter without the endorsement of you, the voters. And so I would encourage you to get to know Alicia Berry, get to know who she is, and get to know what she stands for. And I'm confident that she will earn your vote. Thank you.
Thank you. That's okay. Yeah, I forgot to say don't clap, but that's so you can clap. Okay, Mr. Ekstrom. Watch out for that little piece
I will.
sticking out there.
I will take no offense if you don't clap. Being a Superior Court judge is difficult. You deal with difficult issues, and you hear things that may make you personally uncomfortable. The law compels decisions with which you may personally disagree. But it's not about you. It's about fidelity to a process which yields decisions which are understandable. A process in which decisions are reached in a manner that is fair and unbiased. A process where, based on the separation of powers, the judge leaves legislation to the legislature and does not impose their personal preference, nor even hint at it. If you don't realize that it isn't about you, what you like, what you prefer, what makes you comfortable, you can't do the job. The election process, even for nonpartisans, is also difficult. It's a sacrifice for and a burden upon you and your family. Your entire career and your resulting professional reputation will be subject to scrutiny. You'll be required to appear at your community's parades, forums, and debates. Your professional organization, your local bar, will pass judgment upon you by comparing your qualifications and reputation to that of your opponent. Your local paper will interview and endorse one, but not both of you. Again, you will deal with difficult issues, answer difficult questions, hear things that may make you personally uncomfortable. But if you don't realize that it's not about you, what you prefer, what makes you comfortable, and it's instead about your obligation to allow the community that you seek to serve to compare you to your opponent on your merits, side by side, if you don't realize this, you can't do the job. My opponent isn't here this evening, and she attended neither the Tri-City Herald interview nor the Tuesday Community Forum last week. It's not that she declines to attend all forums. She addressed another group last week as well, and has CC'd for a event a week from today. It's an unfortunate decision. It doesn't serve the process or the community well. The position isn't a ride at the fair. You don't get to pick or choose to avoid the things that make you uncomfortable. I've been honored to be your Superior Court judge for the last 2 years, and to be a public servant for over 18 of those. My commitment to the position is reflected by those who support and endorse me. every serving and retired Superior Court judicial officer in Benton and Franklin County. Prosecutors, defense attorneys, law enforcement, civil attorneys, the endorsement of the Tri-City Herald, and the unanimous endorsement of our local bar. Your vote is important to me. I would ask for your support on November 8th. Thank you.
And so we will begin with Mr. Burrows and his opening statement.
Thank you. I'm Judge Joe Burrows. I'm your Benton County District Court Judge here in Benton County. I'm truly passionate about my job. I'm honored to do the job each and every day, and I've been doing that job for a number of years. This year I'm campaigning to become a Superior Court Judge, and I think that I have the experience, the judicial leadership, and the community support to be your Superior Court Judge. What my colleagues didn't tell you about that I want to make sure you understand is that when I was asked to do this forum, a person asked me, well, what is it about a judicial candidate that I can get to know about you as a person? And what do you stand for? And it's very important that these forums for the people and the voters can understand who I am as a person and who I am as a judge. Who I am as a person, I've been a resident almost 40 years here in Benton County. I'm married to my lovely wife, Sue, and we have 2 children and 2 grandchildren. I love my family. My family's everything to me. I grew up in a military family, and it taught me some really strong values, which I hold today. I have a very strong faith. I love to work hard. I always give back to the community, and I always do the right decision. I traveled the United States. It took me 36 schools to graduate high school, 6 high schools. When I landed in Tri-Cities, I thought this was the worst place on earth to live and raise a family. But it is my home. I love my community. I graduated from Richland High, Columbia Basin College, and WSU Tri-Cities. I'm proud of those undergrad degrees because I did it all at night school. I went to Gonzaga School of Law after 36 years of working, or at the ripe old age of 36, to go to law school, quit my job, and became a lawyer. I became a prosecutor, a city attorney, and a public defender. I am the Dean of Judicial College, representing all the responsibility to teach all the judges in the state of Washington. And I would love to get you to know more about me, but the clock has stopped. So thank you.
Thank you. And Mr. Swanberg.
Thank you. My name is Sam Swanberg, and I am running to be your next Superior Court Judge for Position 2. I am married. I've been married for 29 years. I have 6 children and 1 grandchild, and I'm very proud of that. I have been practicing as a trial attorney here in Benton and Franklin County Superior Courts for the past 23 years. First as a prosecuting attorney, where I was assigned to serious felony offenses, and then in private practice, largely dealing with criminal defense and family law. During that period of time, I have handled over 3,000 felony cases from beginning to end. I have tried more than 150 cases. And as Judge Fearing said, I think experience is the most critical factor in qualifying somebody to be a Superior Court judge, and that experience needs to be in Superior Court. I would point out to you that I'm not the only one that agrees with that assessment. I was endorsed by the Tri-City Herald after they interviewed both myself and my opponent, that they found that I was the most qualified for the position due to my extensive experience in Superior Court. I was also recognized by the local bar association through a unanimous decision that I was the most qualified as well, being found to have the greatest legal ability, the most relevant legal experience, and the best judicial temperament, and their first choice overall for this position. Again, I'm very humbled by that and think that it speaks volumes as to my qualifications, and I'm appreciative of that. I'm also endorsed by more than 100 local attorneys. And I know that attorneys shouldn't decide this, but I think that you need to take a look at that when you're deciding who should be in that court, because those are the folks that really know both myself and my opponent. They're the people that see us in court, know of our reputation, and know of our abilities. I believe that I am the most qualified for a Superior Court judge, and I would therefore ask for your support and vote. Thank you.
Thank you. We'll start the question and answer portion, and we'll begin with Mr. Burrows. Someone has prepared a fairly long question. I will read this. It has to do with Benton County and the jail. Recent rulings find the Benton County Court's imposition of legal financial obligations have further marginalized offenders politically, socially, and economically. The operation of a modern-day debtor's prison ended only after a lawsuit was filed by the ACLU. The Washington State Court of Appeals recently ruled that an arrest warrant issued for Jacqueline Ray Slater was invalid. A judge must determine the defendant's willfulness to violate their payment obligations before an arrest warrant can be issued. And finally, there's another case of Brianna Wakefield, a disabled homeless mother of 4 who struggled to pay the $2,500 in legal financial obligations. The Supreme Court overruled the district's court denial of a motion to reduce and eliminate her legal financial obligations. What policies will you put in place to ensure that only defendants with the ability to pay at the time of their conviction are sentenced to non-restitution sanctions? Did you follow that? You're probably more familiar with it than I am.
I'm really familiar with it because that case came out of my court. I'm very thankful for the Supreme Court, the Court of Appeals, that make decisions to allow us trial courts to follow. Prior to that decisions, or the recent decisions by the Supreme Court and the Court of Appeals, there was no real guidance in the law regarding holding criminals accountable for their fines and costs. There was no policy in place that allowed the judge or to determine their ability to pay not only the cost, but the fine overall. District Court, for a number of years, held criminals accountable for their judgment and sentence after being either pled guilty or found guilty of those financial obligations. Those decisions that have recently came down has impacted the state and the local communities significantly in a positive way. In a positive way, those procedures that went in place that all sentencing judges, when they sentence a criminal defendant, it is paramount that each one of those judges make a determination on their ability to pay based on the defendant's evidence, either a disability or a job, or if they have some issue that may prevent them from paying fines and costs. I welcome the decision because the decision now, as a Court of Appeals in the Supreme Court, gives me, a trial court judge, that guidance to follow.
Thank you. Mr. Swanberg?
Well, I'm grateful for that decision as well. However, I'm of the opinion that it shouldn't take a Court of Appeals or a state Supreme Court for a lower court to understand that it is unfair and unjust to levy fines and fees against the poor that they clearly cannot pay without any determination beforehand that they have the ability to pay. And so although I am grateful that the court has made that decision, I think it is something that I would wish that it was something that that court could have seen for itself without having to be told that.
Okay. There is another question, though, related to that. Do you have what would your strategy be then to hold people that are poor accountable for the crimes they've committed?
Well, where I practice, which is in Superior Court, the court is doing a very good job at this point in time of following the Blazina law that came down, which is that there needs to be a very detailed determination of what a defendant who's been convicted, what their financial ability is for purposes of determining what is a fair fine and what are fair legal financial obligations to be assessed against that person that they would actually have the ability to pay, if any. And so I think that what has to happen is that we just need to keep following Blazina, and we need to be doing a better and better job of doing everything we can to make that financial determination, to make sure that somebody that is poor is not being punished simply because they are poor and have an inability to pay.
Thank you. And Mr. Burrows?
I think I didn't, could you repeat, accountability for the legal obligations or the financial, I'm not certain.
Well, what if they can't afford to pay fines,
Okay.
what other strategies would you have to hold them accountable?
Okay, great. Well, first of all, fines and costs are different. The fine is a penalty. In our statute, criminal defendants, part of their sentence is a fine, and part of their sentence is jail time. the costs that are incurred as a fee, those are the costs that if the defendant has not the ability to pay discretionary costs, for example, costs to the jail, costs for probation, those things are discretionary, and those discretionary costs can be waived or eliminated. The non-discretionary costs that the statute, which I didn't make that law, the filing fees, the DNA taking of the sample, domestic violence fees are not discretionary, and therefore limits the judge to make the determination to either waive it or eliminate it altogether. What's important to know that the decisions that were made by the appellate court and the Supreme Court allows strict guidance that the judge should follow on each and every case. It also provides that there are certain limitations or certain policies that a public defender or others that represent defendants must also follow, and I welcome the change.
Thank you. You can go first on the next question. In our area, a significant amount of crime is related to gang activity. It is often hard to get people to testify in these cases because of fear of retaliation. Do you have any thoughts about how the courts could address this problem?
Let me just say this. Day in and day out, I preside over a number of cases that are gang-related. If it's from domestic violence, trespass, theft, domestic issues, I will just say this. There are a number of cases that have been dismissed for lack of witnesses being either to be subpoenaed or brought to court for the fear of retribution. That is unfortunate, but our justice system, that's how it works. If the witness isn't there to testify, the defendant is presumed innocent. And the confrontation clause allows the defendant to confront those witnesses that are testifying against them. From my perspective, that would be better suited for a prosecution to make that answer. I am a neutral magistrate. I preside over hundreds of thousands of cases. That's not for me to determine regarding the witnesses' availability or gang issues. But I will say this. I get a number of search warrants on a day-to-day basis regarding gang activity in the community. And let me just say they're very active here in Tri-Cities.
Thank you. Mr. Swanberg?
I'd agree that that is not something for the judge to be addressing, unfortunately, that is something that is going to have to be dealt with, if it can be dealt with at all, at the prosecutor level, where they have to be able to give assurance to their witnesses that they are trying to bring in that they are not going to be subject to retaliation from those that they would testify against. With that said, I would hope that the prosecution, I think they do a good job of that. They do the best they can. But it's always going to be a problem.
Okay, thank you. You get to start first. Let's see. In your opinion, is the bi-county court system working well for both Benton and Franklin counties?
In my opinion, it does work well. It works well because of the geographical proximity of the two courts in Franklin County and Benton County to each other. It works well because I think that our community, although on Friday nights we like to divide up and go to our separate games and root for our favorite high school teams, that we are becoming more and more of a community all the time, and I think we think of ourselves that way. It also works well because I think of our population base at this point in time. If this was a situation where we had populations closer to King County and Snohomish County, say, and we had lots of judges in both counties, then maybe that wouldn't make much sense. But where we, based on our population, have a total of 7 judges, it makes a lot of sense because it allows those judges to be able to be most effectively used, because on one particular day there might be more need for more judges in Franklin County than they would typically have if they just had the judges based on their proportional representation. And so it goes as well in Benton County, that they might have days where they need more than they would normally have. And to be able to effectively, therefore, use those judges back and forth to make sure that their time is being utilized most effectively, it makes the most sense. In addition, I can say as a practicing attorney that it makes the most sense as well, that we, based on the population here, that the attorneys can't simply practice in Benton or Franklin County alone and need to go back and forth And having the bi-county system allows us to have dockets that's criminal cases that are held on a docket to be coordinated with each other, which really helps for the attorneys.
Okay, Mr. Burrows?
Thank you. Let me answer the question a different way. First of all, the bi-county agreement is good for the citizens of Tri-Cities, for Benton and Franklin County. Can it be better? Absolutely. Let me tell you why. My experience as a district court judge for the last 9 years, there is a district court agreement between the City of Richland, City of Kennewick, City of Prosser, and City of West Richland and Benton County. That agreement it utilizes resources based on the use of the court system, based on the use of the jail here in Benton County. It has worked well for years. It is, if it's equally shared by all parties by using the system. Now, the question really is about, do I support the bi-county agreement? And I do, because it's good for all of us. When you share resources and the expenses, we all win as a community. We also win as a judiciary because judicial funding is always at risk at any time to fund the court system. It is always in peril at the 1st of January that the judiciary loses funding or either has to fight for funding. We are unique here in Tri-Cities that we're one of the few that have a bi-county agreement. And I'm hopeful that we will improve upon it based on I would say, my election and my experience.
Okay, thank you. This is a question I have that I wasn't familiar with. Washington State has one of the highest property crime rates in the country, according to recently released FBI statistics. Washington is also one of the only states in the country that does not allow court-ordered probation supervision or court-ordered treatment for sentencing for property crime convictions. Do you believe there is a correlation between the high property crime rate in Washington and the court's inability to order supervision or mandated treatment? And what role, if any, could the courts play in correcting this problem?
Great question.
Oh, good.
Great question. In district court, we have a probation department. And let me tell you, when you supervise the criminal defendants for treatment, monitoring of committing crimes, restitution, making the victims whole, they're more accountable for their crimes. In Superior Court, that function is for the Department of Corrections. The Superior Court judges have no authority at the lower level to monitor those particular individuals. While I say that the Department of Corrections does a wonderful job, but I would say that they are just overtasked and overburdened about the amount of resources that they have. It is imperative for the recidivism rate, if you monitor criminal defendants, that they get the treatment and the help they need, it would avoid committing more crimes. And I am in support of those. Those support issues may be therapeutic courts or some other avenues as opposed to incarceration.
Thank you. And Mr. Swanberg?
Well, there are programs within the Superior Court that deal with those things. I think there could always be more. It's not my job as a judge to create those, although I would support them if the legislature did that. But there are things as adult drug court where the prosecutor's office has the discretion on nonviolent crimes, mostly property crimes, to divert those into a therapeutic drug court, if you will, to monitor those individuals while they are going through treatment and being overwatched to see whether or not they can solve their addiction. There's also the program of DOSA, which stands for the Drug Offender Sentencing Alternative, which is run through the Superior Court system, where it allows people that are facing a prison sentence to receive instead, if it's a nonviolent crime or a property crime, where they can, instead of going to prison, they can do 6 months of inpatient treatment at a inpatient treatment facility in lieu of that, and won't have to go to prison if they can finish that and the balance of their 2 years of community supervision, which is the Department of Corrections terms for probation, without having further violations. And so there are those programs that are in place. I think there's a definite link between most of, well, I won't say most, but a lot of property offenses and drug addictions, as well as mental health issues. And that I think really the mental health issue is where we need to start looking more and more as far as programs that need to be put in place to deal with that situation as well.
Okay, we have one more question. We'll follow up on that a little bit. How important do you think the drug court is and the new mental health court will be in providing alternatives to incarceration? And do you think they are adequate in the number of clients they are going to be able to handle?
I think they're critical, absolutely critical. Like I said, there's just a huge problem with the drugs and mental health, and a lot of it crosses over with each other. And unless we address those underlying issues, we're not going to be able to cut back crime any more than what we are right now. Do I think they're adequate? No. We need to expand upon them. There needs to be more available space for people to get into those programs and to be able to take part in it. But that takes funding, and it takes money. And so that's something for the legislature. Hopefully they will look at that and continue to see the need for that and see that it has a correlation to helping to reduce crime. But we lock up over 2 million people now in our country. I mean, I don't know how much further we can go with simply saying the answer is to lock people away for a longer and longer period of time, especially when you're dealing with nonviolent offenses where the underlying problem is obviously drug addiction and or mental health illness, that we really need to be dealing with the underlying causes for these offenses and doing a better job of trying to cut down the numbers of them.
Thank you. Mr. Burrows?
Thank you. Therapeutic court is one of the important factors to curbing recidivism rate and crime in the community. We're very fortunate to have a drug court in Superior Court for over 10 years now, and that was supported locally by the citizens of Benton and Franklin County through volunteers and funding through different charity organizations. With respect to therapeutic courts, we could do a lot more in therapeutic courts. As you are all are aware and that you alluded to, as the co-author of the mental health court and district court, we're currently handling about 30 cases in district court that are individuals with mental health issues that commit crime. We're hoping to do about 90 or so in the system in district court. We're hoping that the budget will be approved here recently. It's going to be about $1.2 million, and that is only from the citizens of Benton County that approved a tax to pay for this mental health, part of the tax for the mental health court. It is imperative that we support these type of programs because it does get individuals out of the system, if you will, and therefore creates an individual that can be a productive citizen, can get out of this lifestyle, and just overall betterment of themselves.
Thank you. We are at the point where we're going to have our closing statements, and you're going to go first, Mr. Burrows. And you have 1 minute.
Thank you. It's an honor to be here. I thank you for the opportunity to speak about this. I am the only candidate with judicial experience. I've been a public servant for 34 years and 12 years of it as a judicial officer. Make no mistake, this is an important election. I will say this, experience is important. No amount of legal experience compares to being the judicial experience that I have. It is important for you to make an informed vote, and you vote for the person that you believe who has been doing the job day in and day out, and I believe I'm that person.
Thank you. And Mr. Swanberg.
Well, I've been an attorney for 23 years in Superior Court. It's more than 18 years more than my opponent. He says that based on being a judge in district court makes him more qualified, but the analogy I would give is being a high school head football coach versus being a coordinator in the NFL, being in the defensive or an offensive coordinator, and the head coach from the high school telling you, well, I've been a head coach, I'm more qualified to be the head coach in the NFL. And I think that just doesn't make much sense. I've been dealing for these 23 years, the last 20 on the defensive side, with these problems that we've talking about today that happen in Superior Court. I'm the one that's been there working with those in the trenches day in and day out throughout my career. I've devoted my career to that court and to those problems, and I'm better able to deal with them, and I'm more qualified. The Benton County and Franklin County prosecuting attorneys both agree with that. They both endorse me. The Herald endorses me. The Bar Association supports me. And almost the overwhelming majority of attorneys in this area do as well. Thank you.
Thank you, and join me in thanking both of these gentlemen for being here tonight.